public spat between the River State Government and the Federal Inland Revenue Service, FIRS, over the administration of value-added tax is not going away soon. This follows the dismissal of an application of the FIRS seeking for a stay of execution of an earlier judgment of the Federal High Court sitting in Port Harcourt, which held that it was a constitutional role of the state government to collect VAT, not the FIRS. Despite the ruling, the FIRS has remained defiant and has directed taxpayers in River State to continue to comply with the VAT Act, pending the determination of its appeal by a superior court. Yesterday also, both Governor Wike of River State and the FIRS doubled down on their respective positions on the administration of VAT. Wike took it a step further by releasing a letter written by the FIRS to the National Assembly last July, asking the legislature to amend the 1999 Constitution by moving VAT administration from the Concurrent Legislative List to the Exclusive Legislative List. The FIRS letter more or less reinforced the judgment of the Federal High Court and position of the River State Government that it is not the responsibility of the FIRS to administer VAT generated by the 36 states and the FCT. Now joining us to discuss all the issues at stake with respect to VAT administration in the country is Liborous Oshoma, a lawyer and regular guest on this show. Welcome to the show, Liborous. Good morning.
Yeah, good morning to you. Thanks for having me.
Liborous, the FIRS is resisting the ruling of the court in Port Harcourt, Federal High Court, August 9, and also another ruling by Justice Stephen Palm with regard to the rights of states to collect and manage VAT. We'd like you to comment on that. And then also on the FIRS appealing to the National Assembly to come up with a bill to include, VAT as an exclusive matter under item 158, and to also accordingly amend section 251 of the 1999 Constitution. What do you think?
Yeah, I would say that what we have really, it's a hangover of the monarchical system that we find ourselves, where the king can do no wrong. By the implication of the FIRS letter, if you look at paragraph 58 and 59, the taxes to be collected by the federal government, admitted by the FIRS, is stamp duties, taxation of incomes, profit and capital gain, except as otherwise prescribed by this Constitution, not prescribed by the National Assembly, by this Constitution. It is not stated anywhere that the federal government should exclusively collect consumption tax. And so the FIRS also know this position. This is not the first time anyway. If you remember the case of UKG and FIRS, the court, the Federal High Court, same Federal High Court, had invalidated the FIRS Act. But it didn't make the news because it wasn't by state government. And then also, sometimes in 2019, the Registered Trustee of Hotel Owners and Managers Association in Lagos State, while contesting the double taxation introduced by the hotel occupancy consumption laws of Lagos State, the courts, the same Federal High Court, invalidated section 1, 2, 4, and 12 of the VAT Act on the ground that it contradicts and conflicts with some provisions of section 4 of the 1999 Constitution. So there's been authorities on that. So what you have is this, the king can do no wrong mentality of, okay, yes, since the federal government is a behemoth, it can do anything. So let's have a situation where we begin to legislate on even areas we do not have powers to legislate on. And so the moment that judgment in 2019 came up, FIRS secretly wrote a letter to the National Assembly requesting them to amend the Constitution to include VAT. But unfortunately, that issue had not been dealt with by the National Assembly before this Attorney General of River State and the FIRS. What I think the states should do is let all the Attorney General join in that suit. It ought to ordinarily should have started from the Supreme Court, being a constitutional matter and interpretation. All the Attorney Generals of the states should have joined in the suit and then challenge that act vis-a-vis the provisions of Section 4 of the Constitution. It's an abnormality. And I think, like before now, like I had always advocated, the restructuring that we clamor for might not necessarily come from amending the constitution, but through interpretations of our laws, because that was what happened in India. In India, what the justiciability of Chapter 2 of their constitution, which is similar to us on the fundamental objectives and directive principles of state policy, was done through the courts. It was the interpretation that the court gave to it, that you can sue, that these rights are not just right donated, and that they are justiciable. And so in the same vein, I think it is high time that our courts should stop this attitude of conflicting judgment and let them be unanimous on issues such as this and expand the frontiers of our legal jurisprudence.
Liborous, you never leave home without your constitution.
Yes, yes, yes.
I've observed that.
It's always in my car.
So what do you make of Governor Wike's allegation that there are attempts to move the appeal from a Port Harcourt court to an Abuja court? And what's the import of jurisdiction in this context?
And that's why I am saying that to follow up on the steps taken by the Chief Justice of the Federation recently when he invited some state chief judges on the grant of ex parte application, frivolous ex parte applications, the judiciary should refuse to be used by the federal government to do dirty jobs. It is clear, it is obvious, even admitted by the FRS also, that they do not have power. The law does, a law that does not derive its powers from the ground norm and supposedly given powers by the ground norm, it's a law that is inconsistent with the ground norm. So any attempt to move that matter from where it is to a court that will be favorably disposed to granting judgment to one party will automatically take away the already non-existing or the already whittled down influence of the judiciary in as far as democratic practice today is concerned in Nigeria. And so the courts or the CJN should resist. Even I trust the President Court of Appeal. She's not a woman with the, what do you call it, the long and short battle that she had to go through it before she was eventually confirmed as President Court of Appeal. I know that she would resist any attempt to be browbeaten into doing that because it is clear. The judge, even the judge has said, look, this is not a matter you ask me to grant a stay of execution on. You're asking me to grant a stay. And here the court had denied granting stay. You are still asking parties to go on in violation of a court judgment, to go on paying VAT to you. What it means is that the Federal Inland Revenue Service already are working on an answer, and they probably will be looking for a court that will just work from that answers to the questions. And it should be resisted by all the state governors, including the ones that feels they will not benefit from this position. What it means for Nigerians is that for you to become a governor, you must be ready to work. We agree that in other states, in other countries, richer states would contribute at least a percentage to the federal to support, the weaker ones. That is when the states are vulnerable, but not in this case. In this case, what you have are lazy states. That's why we are all agitating for state creation. You know that you create state. Some governors live in America. Some live in Abuja persistently. At the end of the month, they collect allocation, go back and share, and then back to Abuja. We can't build Nigeria like that.
Right. I understand we'll go on a quick break. We'll go on a quick break now. We'll come back and we'll talk some more of the verse.
Thank you.
We'll be right back. All right, welcome back to the morning show right here on the Rise News channel. We've got Liborous Oshoma here, a lawyer and a regular guest on our show, the morning show right here. Liborous, great to see you once again. So, is it? I want to ask: is it that the FIRS themselves knew that they were in the wrong all this while? That was why they tried writing. They wrote a letter actually.
Writing the wrong.
Yeah, writing the wrong. A letter to the National Assembly to put this in the Constitution. Because with the emergence of that letter that was dated July, they knew this hammer was going to fall on them, obviously. So they wrote that letter, trying to talk to the National Assembly to help them put this on the exclusive list of the Constitution while they fight their court battle on the other hand and they are looking for stays of execution everywhere. Because with the emergence of that letter, it shows that something was happening.
What happened was immediately after the court judgment in UKJ and FRS, where the courts, the Federal High Court, heard that the the VAT Act was contrary to the provisions of the Constitution, having not derived its origin, its source from any provisions of the Constitution, and also on the ground that the National Assembly, by virtue of Section 4, does not have powers to legislate on consumption taxes. So, and then the registered trustee of hotel owners and managers' judgment to that effect also. That was when they wrote a letter to the National Assembly. They won the Attorney General of Rivers State and the FRS came later. So because those other two cases were not widely reported, so people didn't know what happened. And so that's why this matter is not novel. If you remember, in pre-2015, Ade Ikpaye, who was a special advisor on taxation to the then governor of Lagos State, that's Fashola, had consistently fought this VAT matter. I remember I was even on a platform with him where he had advocated that there was no need, this same statement that Wike is reiterating today, that there was no need a situation where some persons are destroying alcohol up north and then collecting VAT from alcohol in Lagos, that it was hypocrisy. And so I had expected that the moment they came into government at the center, these were some of the things that they were going to correct, having been advocates of some of this restructuring at the state level. So all of this now is just coming to fore because it is a state government that is challenging that law. Others have consistently challenged it. Hotel owners in Lagos have challenged it, that it was double taxation for them, because as we speak in Lagos State, VAT is not charged on food and alcohol consumed in hotels and event center, because there is a law in Lagos State that charges taxes on those consumption and validated by the Federal High Court in Lagos. So this had been a running battle, but because we also have lazy governors, just like, sorry to digress a little bit, I hear Autumn most times saying, I will sue Buhari, and I ask myself, why do you want to tell me that you want to sue the federal government? Sue, and then let the court decide. So because we have lazy governors who will not test the provisions of our laws, so you have these issues, we debate them, and then they tell you, look for human rights lawyers to challenge, and then you get to court, they tell you, what is your locus? But when it is challenged by an attorney general of the state, who is, the chief law officer of the state, or the association that it will bear the brunt if these laws are implemented, you find it very difficult, very easy for the court to make a pronouncement, and which pronouncement had been consistent in all of the judgments on this issue. That's why the FRS surreptitiously quickly sent a letter to the National Assembly pleading that there should be an amendment and VAT should be listed amongst collections for the federal government under the exclusive legislative list, because it is not there.
Okay, Liborous. Yesterday, Governor Nyesom Wike of Rivers State held a meeting with stakeholders, companies and other bodies that pay VAT in Rivers State. I just want you to evaluate some of his submissions. One, he's saying that he will seal off FRS offices in Rivers State if FRS continues to insist on collecting VAT. Two, he said from this month, September, Rivers State will start collecting VAT in Rivers State, and that any company that does not comply will also be sealed off. Three, he said that Rivers State is going to make a move to collect the backlog of VAT that have been collected by the FIRS, and that he's insistent on that because the FIRS cannot bully Rivers State. Four, he said that Rivers State is going to use his own security outfit to enforce the positions that he had articulated, and that they are not going to use the Nigerian police, and that he's determined to take all of these steps. Which one of these steps is legal Which one sounds like a resort to self-help?
This last one is a resort to self-help. The position of having to resort to your own security outfits. A security outfit, though recognized by the laws in Rivers State, but not empowered to use the kind of force that you probably use in situations such as that. Because even enforcing a law, you have to also resort to the provisions of the law to enforce a law. That's why I believe that for the FRS, this is a matter I think parties should come to a round table to discuss. Because the people, those that will bear the brunt will be business owners. Business owners are unnecessarily going to have to pay double taxation in cases where ordinarily it should be one. So that's why, for me, I think the FRS should come down from their high horse and sit at a round table with the governor. One, first and foremost, an appeal in itself does not act as a stay of execution. And especially also, in most cases, parties are asked to maintain status quo so as not to force a fait accompli on the court. But in this case, you have also filed a stay of execution. And according to this Governor Wike, he said while the stay of execution was pending, he had asked the Rivers State government not to interfere, not to collect VAT, even though they had a subsisting judgment. But now that the application for stay had been dismissed, the FRS insisting that they were going to go contrary to the subsisting position of the law, because the law is what the court says it is. Contrary to the subsisting position of the law, to insist, because you have an appeal that had not been decided one way or the other, that we are going to go on with the status quo, that will mean a call to anarchy. And that's why I think that for Wike, yes, the other steps taken, insisting that he was going to collect backlog. Collecting backlog would mean sitting down on the round table also with FRS. And then also insisting that henceforth he was going to comply with the provisions of his law also would mean sitting down with FRS and drawing up modalities to enforce it. But resorting to self-help, wanting to use the state security outfit, for me, it's a no-no. It shouldn't be. Even though we know the federal police, in cases like this, will want to compromise, but the same governor has police task force as in his retinue of security outfit. You have Nigerian police guarding government houses. So you should also still resort back to the police, even though, yes, the commissioner of police in the state reports to the IG, but yet we have never seen situations where state governors will say that they requested for police supports at times like this, and that such requests were refused by the state commissioners.
Well, that's another level of federalism that I'm sure we'll be approaching very soon.
Yes.
But I want your take on the lengthy news conference held by Mr. Gwajubola, the lead of FIRS Special Operations, talking about the output-input mechanism that makes it, in his opinion, unadvisable for FIRS to be collected at a subnational level so that businesses don't have to pay twice.
The issue here is consumption. Call it whatever name you want to call it, value added, or it is consumption tax. The question had consistently been all those sharing formulas, input, output, where the federal government had consistently collected 52%, you share 20% to the local government and then share 22% to the state government. The governors had consistently, including the Revenue Mobilization and Fiscal Commission, had been asked to review sharing formulas over time. So if there must be a review, why don't you also look at the laws that governs tax collection? Personal income taxes, for example, are collected by states. If you allow the Nigerian federal government, they will collect it. They will tell you to avoid double taxation. But the state are saying, no, there are these consumptions, produce that are consumed in my state, and you collect revenue on them. There's need for us to have that revenue so that we'll be able to at least take care of those areas where these consumptions are coming from. It will be too much to ask of a state government if we truly believe that we operate a federal system of government. But here, for me, I listened to the length of that press and it didn't really speak to the issues. The issue is legality. Is it part of the law, the VAT Act 1997, does it derive its origin from our constitution? If the answer is yes, let it go. If it is no, then find a way around it, or allow the state government that are empowered, constitutionally empowered to do this, to do all this. The rest for me are technical issues that, you know, you just, when you know you have been defeated, you ramble around.
Which is why he said he hadn't heard of that, you know, proposal trying to float a bill to amend the Constitution.
But the letter is before him, whether he accepts, whether he denies. There's a letter to that effect. And I also think that what the state governors should do also should be to call the members of the National Assembly to order, because we know this is the same National Assembly. Call the members of their National Assemblies, sit down and have a position. It shouldn't be a party thing, the way they did with, they should do it the way they did with, what do you call it, the electronic transmission of results. It should be that, look, this would benefit the states more and not the center. It will benefit the state more. Then all of these issues of constituency votes and having to, everybody coming to Abuja to look for money, you can send them back to the state to say, no, we generate enough money now. And then the state governors will look for ways to create, you know, industries, attract investors to their state, because they know that invariably you have a lot of people, you know, within the tax net. But if you consistently insist that it should be a federal thing, so that, because like they say, when you have a glutton in the family, he says, let's eat together because he knows he will eat more. So you insist that it continues to be a federal thing. Then what you're doing is that you're killing the goose that is laying the golden egg, because it will encourage laziness.
Okay, so two things. Number one will be, part of his statement when he was speaking yesterday, you know, the rep from the FIRS, he said, when you look at these taxes, most of these taxes are collected by, you know, VAT, for instance, are collected by establishments of government. So take, for instance, the custom. When you import a good and you pay VAT to them. He also made the case of the fact that when you look at the pecking order, the second place where you collect most VAT from is Abuja, because of government contracts and MDAs and the likes. I mean, what's your reaction to that? One. Number two will be what is happening currently in Lagos. I saw a draft of a bill yesterday Lagos State has put forward. That might be, in fact, I think they had a public hearing yesterday as regards it. They're saying 6%. There are some other provisions in that bill that nullifies, you know, obviously the Finance Act. They're saying 6%. There's no that 25 million threshold, you know, of companies. And what they're also saying further is, okay, they are going to, their normal laws, the 21st day, that's when they collect the tax and all of that. But I'm saying, I want to ask that, will automatically, that 6% Lagos is saying, nullify the 7.5%? Would you also automatically nullify the consumption tax we pay if you go to a restaurant to eat now of 5%? So is it going to be now VAT plus that consumption tax of 5%?
No. VAT is a consumption tax.
Yeah, but we're paying a consumption of 5% now.
Because you are paying to the state government.
To the state government.
Meanwhile, the federal government is collecting VAT. So what you have is double taxation. So in the event that the invalidity of the VAT is sustained, and then you revert to the state, what you're going to have is that the states are going to enact laws, just like Rivers State had done, to harmonize all of these taxes. And then to the issue of customs. This idea of, because a tax is collected by a federal government agency and so it should be sustained, for me is also neither here nor there. There are other taxes that the custom collects on imported goods. You must not collect everything, because these same goods that are imported, mind you, when they get to hotels, the state government will collect consumption taxes on those goods. So meanwhile, you have paid VAT on them to the federal government, you are still paying a consumption tax to the state government. So I think, that's why I said it's a novel area that most state government don't even understand, including the FIRS. They need to sit down, and there's need for all parties to sit down and have a workable arrangement. This idea of, no, because of what we have put in place or because of the technicality of the issues, it is still good for us to continue in error. That's what the FIRS is saying. Let us continue in error because of the technicalities of the issue. No matter how technical the issues are, you can sit down and unwrap them, and at the end of the day, get to the bottom for the benefit of business owners and the consumers, So that's basically it. And then for Lagos State, because all of these are happening because a situation where you refuse them from collecting taxes on goods that they ought to tax. They find a way around it by introducing other taxes, but you won't know because it is minute, it is very minimal. But at the end of the day, it adds to the general cost that the consumers will have to pay, especially in an area where you hardly even produce. So last year, the VAT collected from the highest was from Lagos State after FCT. The next was from Lagos State. But what did Lagos State get in return from these same taxes? And so when they look at that, when they look at their balance sheet, they are going to say, look, we generate so much, give to federal government, and yet we don't make so much money. But this also, I will tell you, we open another frontier on the issue of the oil producing states, because that's also the what do you call it, the Petroleum Industry Act now, you would think had been buried. But with this VAT or no VAT, that will also resurrect the issue of, revenue from oil, because some people already raising it. So there's need for us to allow this, expose and what I would call expansion of our legal jurisprudence for the benefit of deepening our federation.
Well, Liborous, I'd like to draw your attention to the front page of Daily Trust, the lead story, saying 30 states risk bankruptcy as Lagos Rivers search for new VAT regime. Well, it's not just Lagos and Rivers. Akwa Ibom is joining. Adamawa has also served notice that it will enact its own VAT law. But we're being told in this story that 30 states will go bankrupt. And some people have been saying, because of that, then the constitution should be amended so that other states can be protected, since we say this is a federal state. But some people are saying, no, the main issue is about fiscal federalism. Any state that will sink should sink. But what do you think?
I will not be an advocate of us continuing in error, because you have some states that will sink. And also, I will not be an advocate of allowing states to sink. That brings us back to collaboration. There's been this before now also. If you remember, there was a time the Western states mooted an idea of a railway line that would crisscross the entire Western states. And then also bringing back the glorious days of Odua, the Odua group. And with this, when you know that you are not viable as a state, it's either you look for an alternative way. And in fact, but before I go there, the federal government, we see in America, federal government bail out states. That's what this revenue sharing should be. In a situation where you have weaker states who are not able to meet up, it is the duty and the responsibility of the federal government to, at interval, bail them out. But not consistently, not in all cases. But in this case, what the states should do, the states that already, even with VAT, some of them are already going bankrupt. The status of their portfolio, their debt portfolio is unimaginable. And that's why some of them can't even pay salaries consistently. 18,000 minimum wage, how many states governors are paying with the collection of VAT? So if you now remove VAT, a lot of them will sink. But what we're saying is, for me, is the fact that we need to have governors that will think outside the box. We need to have people at the helm of leadership who will think standing. Now there is no more free lunch. There's no more free money. If it means collaborating, creating collaboration between my state and the next state, if I want to go into agriculture and encourage agriculture, look at what Kebbi did before, during just before 2019, I think it was 2016, 2017. They collaborated with Lagos State. Almost all the rice consumed in Lagos State in that December were produced from Kebbi. And it still wasn't enough. So why will other states just fold their hand and sit down and allow terrorists to run riots, and then you're looking for amnesty for terrorists in one breath? Because money will always come from the center. So let's move away from this idea of feeding bottle federal government, feeding bottle system of government, and have fiscal federalism that this same party had been agitating for while they were in opposition. So the time is now. I'm not saying the states should sink. I know they won't sink. They won't sink. It will only mean that the governors will have to double their effort at providing for their people. And then the people will look inward to say, look, Mr. Governor, if you cannot provide alternative, then you are not fit to be governor. This idea of people just coming and then because somebody said come and be, and you campaign, your posters are everywhere, you are voted for, and there is no idea on what governance should be. You look for a way to borrow because you know allocation will come from the center. Now, even the banks will no longer lend monies to states because your balance sheet will show that you are capable of paying. So it is not a question of, allow us to continue in error in unconstitutionality because we have some persons who will not be able to run. Those that can run should run, and those that can't run should walk. And yet you still have the big brother, federal government, that is still maintaining about 52%, 52.4% of the revenue. And so you can always find a way of assisting some of these states. You still have oil revenue, give 13% derivation to some, while you use the others to support the other states that are creeping. So it's a way of actually starting a new paradigm, a new vista where Nigerians should gradually be moving to. For me, that's the beauty of the whole thing.
Yeah, here. Well, I'm not sure how long we have, but in the next maybe 1 or 2 minutes, we have to have your take on the scandal of ex parte orders and conflicting court rulings from courts of coordinate jurisdiction. I
had said that is a big mess that the bar and the bench, not just the bench had taken steps to correcting. I don't know how far that will go. But the bar also need, because applications don't just file themselves. It is lawyers that are filing them. And in most cases, senior lawyers. So what has happened to some of these lawyers that have filed this frivolous application? And like Justice Kayode Esho of blessed memory, JSC, once said, behind every allegation of bribery and corruption against a judge, there is a lawyer, a senior lawyer who is a conveyor belt. So for us to go beyond, it didn't start today. Remember the June 12th annulment was via an ex parte order.
June 10, 1993.
Oh,
Justice Basi Ikpeme. Judgment delivered midnight.
And so, when you hear of things like this, even during the military era, you had judges that were more confident than what we have now. Because you also need to look at the appointment of some of these judges. The Bera is from me, he will cope. Put him there. You have children of judges. You have girlfriends and wives of, senior lawyers. Yes. And so when you have all of this, it's a big pot of mess. But we must clean it one way or the other. And bribery, allegations of corruption, it's beneath all of this. There's one that happened in Calabar, in Akwa Ibom. If you remember, Professor Peter Ogban, who was convicted by the Akwa Ibom Ikotekpene High Court for electoral malpractices. Justice Pius Idion granted him bail pending appeal, even though, according to the record, according to the judge, that he did not meet any of the criteria for granting such a bail pending appeal. But you had a senior lawyer, you had a senior advocate of Nigeria who came, moved that application, who was on the other side, even at the tribunal. So when you have issues like this, it is enough for the CJN to call the CJ of the state concerned and say, look, from now on, if there's, excuse me, if there's any of such frivolous orders, the CJs will go in for it. And also, I also like the fact that the NJC should no longer wait for petitions from parties involved. Because you don't expect me, as a lawyer that will appear before that same judge tomorrow, to be writing a petition. In some cases, when I do that, we're talking about being senior advocates now. In some cases, they'll tell you have to keep quiet. So when you do that as a lawyer, what fate do you think will befall you? But when the institution that is constitutionally saddled with the responsibility of discipline erring judges is to immediately activate the instrumentality of the law to deal with such cases, it sends a strong signal to parties concerned. So tomorrow, if a senior lawyer comes to you and threatens, you say no, because my job would be on the line while you still be practicing your law.
Well, thank you very much, Liborous Oshoma. But let me tell you that I have one big takeaway. Your identification of wives and girlfriends as one of those dimensions to the dispensation of justice in Nigeria. I thought they only talked about WAGs with relation to football. But that's a new one. I will do further research on it.
No, check. You will find out. Even in the last appointment, there were allegations.
About wives and girlfriends.
Yes, written by Professor Odin Kalu.
They didn't teach us that in the faculty.
Exactly.
Maybe one day it will become part of the curriculum.
Maybe.
Thank you very much.